Hello, my name is Stephen Overholt, and today I will be covering Chapter 10, Contract Performance, Breach, and Remedies. I'm going to be concentrating more on contract performance more than anything, but I will get onto the other topics further on in my discussion. Just to give a quick overview of what contract performance really is, it's defined as being the fulfillment of one's duties arising under a contract with another, the normal way of discharging one's contractual obligations. Discharging is defined as being the termination of this obligation. This occurs when both parties have fully performed their contractual obligations. This also occurs when the conduct of the parties or operation of law releases the parties from said performance. The conditions of performance, there's two. There are condition and condition precedent. Condition is defined as a qualification, provision, or clause in a contractual agreement that can create, suspend, or terminate obligations of the contracting parties. I made a little example of what a condition could be. My example shows Michael is offering to purchase Abby's stamp collection. The stamp collection is appraised at $5,000. The obligation is conditioned on the outcome of Michael's independent appraisal of said stamp collection. If it comes out that it is appraised at $5,000, then the performance has been set and they can move forward with their agreement. A condition precedent is defined as a contractual agreement. It is said to be a condition that must be met before a party's promise becomes absolute or agreed upon. I have an example here of a condition precedent as well. My example shows David is renting an RV from his friend Tom with the option to buy under said condition that David completes regular checkups on the RV and ensures all safety requirements are up to code. If David were to neglect to check the oil, make sure that everything is set up with the RV correctly before it takes it out on the road, then this would be considered a breach of contract, and Tom could decline any sort of a condition to purchase said RV. The next topic would be a discharge by performance. This is basically a contract comes to an end, or when a contract comes to an end, when both parties fulfill their respective duties by performing their acts. Within this, there is the definition of tender, which is an unconditional offer to perform said obligation by a person who is ready, willing, and able to do so. I have an example of this as well as far as tender is concerned. My example shows Bill. I have him listed as a vacuum salesman and Jan as the buyer of said vacuum. Bill tenders delivery of Jan's vacuum and can demand payment. Jan, on the opposite end of the spectrum, offers to pay for the vacuum, and therefore she has tendered payment and can demand that Bill deliver said product. Along with this, as far as performance is concerned, there are actually two types of performance listed as both complete performance and substantial performance. Complete performance is pretty much cut and dry. It's pretty simple. When a party performs exactly as agreed, there's no question as to whether the contract has been performed. Substantial performance is a little bit more in-depth and has more of a gray area. It is listed as when a party in good faith performs substantially all the terms of a contract. They can then enforce the contract against the other party under the doctrine of substantial performance. There are two ingredients as far as substantial performance is concerned. Number one, in order to make sure that this performance or agreement has been met, number one, this variance must not vary greatly from the performance promised in the contract. And number two, it must create substantially the same benefits as those promised in said contract. As far as substantial performance is concerned, one of our chapter questions for this week I found to be a great example of this, and I thought I'd show that as said example. This would be the Kaplans. versus Faithful Construction. Basically, as I'm sure most of you already read, the Kaplans contracted out Faithful Construction to build their home under the specifications that all plumbing and fixtures be the Crane brand. The Kaplans went away from the home for a period of time, leaving Faithful Construction in charge of said operations. And it is shown in the description that Faithful Constructions was unable to use said brands of Crane brand, and therefore consequently uses an equivalent product called Kohler products. Upon returning to their home, the Kaplans discover the substitution and are not pleased with it and refuse to accept the home, claiming that FC or Faithful Construction breached said contract. With this substantial performance, my interpretation of it was that Faithful Construction did not intentionally fail to comply with the request of the Kaplans and installed a comparable product. They didn't just ignore what they had done or what they had requested. They went out and tried to find the Crane brand product, but were unable to do so. With the replacement of the Kohler products, due to the fact that the Kohler products did not vary greatly from Crane and described as offering the same benefits promised and substantially held up their end of the contract, and that I personally believe that the Kaplans would have to accept the Kohler products that were used in this scenario. As far as the case that I have decided to use, I have used the case of Hallmark Cards Incorporated versus Janet L. Murley. Janet Murley served as Vice President of Marketing for Hallmark, wherein she was responsible for product and business development, advertising, and research. Due to the company restructuring, she was let go. However, when she was let go, she was given a very nice severance package equaling out to $735,000, 18 months of paid COBRA insurance, paid tax preparation for 2 years, and given executive outplacement services. In exchange for this, she agreed to not work in the greeting card industry for 18 months. She agreed to not solicit Hallmark employees, to not disclose or use any confidential Hallmark information, or to retain any Hallmark records or documents. She also waived any claims against Hallmark arising from her termination. Murley was hired by a consultant as a consultant of Recycled Paper Greetings, another card company, at the end of her non-compete agreement, and was paid $125,000. For that $125,000, she provided RPG, or Recycled Paper Greetings, with a number of confidential documents from Hallmark, which she held on to and obtained. When RPG acquired American Greetings, a larger subsidiary, they disclosed and made known to Hallmark this crucial information that Murley had given to them, and therefore consequently Hallmark resulted with Hallmark placing a lawsuit on Miss Murley. The way that I read this news article was that literally days before her court hearing, Murley deleted a number of files from her computer that were Hallmark related, that could not be used as evidence because she knew that they would be detrimental to the hearing. As a result of this, the court ordered an adverse inference spoliation instruction. The jury returned a verdict in Hallmark's favor from this, rewarding them $860,000. That number is coming from equaling out to Murley's severance pay plus her consulting fee from RPG. I did have to do a little bit of research because I didn't actually know what the adverse inference instruction was. Basically stating that prior to the ruling, there was a dispute about whether an explicit finding had been made on the record, and that the evidence was destroyed in bad faith. Basically, the circumstances of the trial court proceedings indicated that the judge made a finding of bad faith, meaning basically that Myrlie intentionally destroyed these files that she had on her computer from Hallmark that were going to be key evidence in said case. Myrlie objected to this several times, yet it was never overturned, and therefore they determined that it was done in bad faith, and that she had destroyed the files in her own defense. Pertaining to this case in particular, the verbiage that I took away from it that did pertain and connect to said Chapter 10, specifically more than anything, was this breach of contract. The notation from the news article stated that basically on May 14th, 2009, that Hallmark did file this suit against Myrlie alleging breach of contract through the conversion of Hallmark's confidential information that she obtained and held on to and saved on her computer and then distributed to her new company. It was later found out that the Hallmark had hired a forensic computer company that had discovered that she had destroyed the information that was still saved on her hard drive, and that information was distributed to her new company. Also, condition was used during this case. I took certain notice of that several times. Just from the beginning of the news story itself, where Myrlie agrees not to work in the greeting card industry for 18 months, or more importantly, disclose this detrimental information in return for the severance and paid insurance. She took that information that she obtained from Hallmark and distributed it to their competitor at her new position, which obviously could hurt Hallmark's business. And lastly, we have, as far as the compensatory damage, the jury ultimately returned a verdict in Hallmark's favor. This was obviously monetary, and they equaled it out to be the $860,000, which, as I mentioned earlier, equaled out to Myrlie's pay plus consulting fee.